All right. Hello, everybody who is online, and thank you for joining us. It's just turned 1 o'clock, so we are going to get a start today. So welcome to the webinar. We are today talking about the ACT Child Safe Standards and the Working with Vulnerable People scheme. You'll probably have noticed that we have turned off video and sound for all participants. But we do have a Q&A function running, so you are welcome to post questions at any time into the chat, and we're going to have a Q&A session at the end of the presentation today. I just want to note that we are recording today's session, and we may publish this recording up on our website at a later date for others to access. If you would like a copy of today's slides, please contact our team at the conclusion of the webinar today. Okay, so to start us off, I would like to acknowledge the traditional custodians of the lands that we're meeting on today, which for me is the Ngunnawal people, and I pay my respects to elders past and present. I also acknowledge the emerging leadership capacity of First Nations children and young people and the importance of culture in giving their lives strength and meaning. I also acknowledge the enduring connection to country of all Aboriginal and Torres Strait Islander peoples and the ongoing impacts of dispossession and colonisation, recognising that their rights to these lands have never been ceded. I would also like to acknowledge the survivors of childhood abuse, including the adults, children and young people who have experienced harm in all their forms by those generally entrusted to protect them. I recognise the courage of survivors of institutional sexual abuse who shared their experiences with the Royal Commission into Institutional Responses to Child Sexual Abuse, with the hope that all children will be protected, believed and safe. And many of those survivors that did that have really underpinned what we're here to talk about today. So thank you. So my name is Gemma Rowe. I am the Senior Capability Development Officer working on Child Safe Standards at the ACT Human Rights Commission. And with me online today is Isabel Gath, who is the Assistant Director from the Risk Assessment and Investigations team at Access Canberra. Isabel's going to be presenting on the Working with Vulnerable People scheme, and she's also supported by Kathy Bandala, who's online also. We are going to share these contact details again at the end, so we welcome you to reach out to us if you've got any questions or you'd like support in implementing either the Child Safe Standards or meeting your Working with Vulnerable People or obligations. Okay, so today we're going to cover some of the regulatory frameworks for the Child Safe Standards and Working with Vulnerable People scheme. I'll give a brief overview of the ACT Child Safe Standards, and then Isabel will walk you through those obligations for organisations under Working with Vulnerable People, including compliance, monitoring and reporting. We'll then finish off with a look at the role of working with vulnerable people in child safe recruitment and some practical actions that might help you when you're implementing recruitment practices. Okay, so to begin, in the ACT, there are a number of legislative requirements that address child rights, safety and well-being. These form a protective framework, so we call it the protective framework to prevent harm to children and other vulnerable people. It includes the Human Rights Act, which was introduced in 2004, and the Children and Young People Act in 2008. So these early laws introduced some key requirements in relation to child rights and promoting and protecting safety of children and young people. These two early acts also introduced the idea of decision making in the best interest of the child. Now, in the early 2000s, there was also increasing public debate and scrutiny about the problem of child sexual abuse in institutions. And this led to two key things. Firstly, the development of worker screening across Australia, which in the ACT is, of course, the Working with Vulnerable People scheme, and that came into force in 2012. It also resulted in the Royal Commission into Institutional Responses to Child Sexual Abuse, which got announced in 2012 and ran all the way through till 2017. Now, the Royal Commission heard from thousands of survivors of childhood sexual abuse, and it found that more needed to be done to prevent and protect children from abuse within organisations. The Royal Commission made over 400 recommendations on how to improve laws, policies, and institutional practices to prevent and respond to child abuse. So from the Royal Commission, the ACT reportable conduct scheme was introduced in 2017, and the Child Safe Standards, which is the most recent law, came into effect from 2024. Now, reportable conduct aims to ensure that organisations working with children report allegations of child abuse and misconduct to an oversight body, and that those organisations have appropriate procedures for handling allegations. And the Child Safe Standards aim to prevent harm and create those organisational cultures and practices that promote and protect the rights, safety and well-being of children and young people. So there's a number of laws, and there are also a number of agencies involved in implementing this protective framework for child safety. So it's quite a complex space. But of course, the Child Safe Standards is being led by the Children and Young People Commissioner, who is part of the ACT Human Rights Commission. And the Working with Vulnerable People scheme is delivered by Access Canberra. So that's who you have online today. Just to complete the picture, the reportable conduct scheme is administered by the ACT Ombudsman, and that Children and Young People Act is implemented through the ACT Children, Youth and Families Directorate, and they are responsible for things like child protection and child safety reporting, like mandatory and voluntary reporting. Of course, where a concern relates to child sexual abuse, this should also get reported through to ACT Police. But we're not going to be covering reportable conduct or mandatory reporting today. Just important that you understand that they are part of that protective framework. So today we are here to talk about child safe standards and working with vulnerable people schemes. And in particular, we're going to look at some of the crossover between the two schemes as well as the differences. So the Child Safe Standards apply to all organisations that provide services to children and young people. Organisations that do provide services must ensure that they're implementing the standards. And staff and volunteers in these organisations absolutely have a role in supporting implementation, but the standards and the obligation is primarily sitting with the organisation. In contrast, the Working with Vulnerable People scheme has a narrower scope and applies only to people who are working or volunteering in a regulated activity. So Isabel will get into what a regulated activity means a little bit later, but I just want to make a note at this point that regulated activity is defined in the legislation, and it doesn't mean every single person who works in an organisation that provides services to children. Under the Working with Vulnerable People scheme, the organisations have obligations to ensure that the staff and volunteers have the right Working with Vulnerable People registration, but individuals also have legal obligations to make sure that they hold a Working with Vulnerable People registration if they need to. So it's a shared obligation. Okay, so a brief recap now on the ACT Child Safe Standards. The standards were introduced from the 1st of August in 2024, and they require organisation to implement 10 child safe standards, which are up on your screen at the moment. The standards are aligned to the national principles for child safe organisations, which were a recommendation of that Royal Commission. But there is a key difference because the Royal Commission related only to child sexual abuse, whereas the ACT Child Safe Standards relate to all forms of abuse and harm. So this is physical abuse, emotional abuse, sexual abuse, neglect, bullying, discrimination. Organisations that provide services for children means anybody under the 18 years old, and they've got to do this. They've got to commence the implementation. So it's not you've got to do A, B, and C. You've got to start implementing these standards, and you have to do everything that you can to keep children safe from harm. And the standards really are about those organisational practices that happen within the institution itself. So it's separate from harm that might be happening elsewhere in a child's life, for example, in their community or in their home life. The scope is very broad. It absolutely covers key sectors like early childhood education and schools, religious organisations, sporting clubs, out-of-home care, healthcare, clubs and recreation activities, and even commercial services. Now, as I said, the standards are an organisational requirement, so they focus on that organisational culture. And it's really broad what we can look at doing. So things like having policies and procedures for how we keep children safe, strong codes of conduct and practices for interacting and engaging with children, ways to communicate and engage with children and families, staff screening, risk assessment, reporting and investigation mechanisms for concerns. This is all covered under the Child Safe Standards. And really the intent of the Child Safe Standards is to guide organisations to be what we call a child safe organisation. Now, a child safe organisation does three key things. Firstly, it creates an environment and culture where children and young people's safety is at the centre of thoughts, values and actions. So that's a really child first mindset. Secondly, it's an organisation that places emphasis on genuine engagement with and valuing of children and young people. So this is hearing children's views and involving them in decision making where we can. And then thirdly, it's an organisation that creates conditions that reduce the likelihood of harm occurring. It increases the likelihood that if harm is occurring, it's going to be identified or detected. And the organisation is responding appropriately where any of those concerns or allegations come up. All right, I'm now going to hand over to Isabel to give an overview of the Working with Vulnerable People scheme.
Thank you, Gemma. My name is Isabel. I'm the Assistant Director of the Working Vulnerable People team's Risk Assessment and Investigations Unit. To start, I'll give you a quick overview of the Working Vulnerable People scheme. So as Gemma mentioned, the scheme first came into effect in the ACT in 2012. The scheme is administered under the Working Vulnerable People Background Checking Act of 2011. And the scheme is part of the protective framework within the ACT, which is designed to protect children and other classes of vulnerable people from harm. It's a very broad scheme that includes working with children, working with disadvantaged adults, and NDIS worker clearances. All decisions made under the Working with Vulnerable People Act must place the best interests of vulnerable people as the paramount consideration. This is specifically set out in the Working with Vulnerable People Act, and essentially what that means is that sometimes decisions will be made that are not in the best interests of applicants or registrants, as the best interests of vulnerable people have to be prioritised. Under the Working with Vulnerable People Act, a vulnerable person is a child, so any person under the age of 18, or a disadvantaged adult accessing a regulated activity in relation to their disadvantage. And I'll go into more detail about what a regulated activity is soon. So, regarding the scope of the Working Vulnerable People Act, not all roles that involve contact with a vulnerable person require a Working Vulnerable People registration. A person needs to hold a Working Vulnerable People registration if they are engaging in a regulated activity. So this means an activity regulated under the Working Vulnerable People Act. There are 25 regulated activities and they are all specifically listed in Schedule 1 of the Working Vulnerable People Act. So that's where you should go if you have any questions. I'm not going to list all 25 regulated activities now, but they include services specifically for children, such as teaching and childcare, and services for all vulnerable people, such as coaching and tuition, disability services, and services for migrants, refugees, and asylum seekers. So in addition to being a regulated activity, the role must involve more than incidental contact with a vulnerable person. So the person is not just working in the same building as a child, there is actual physical contact or communication with a vulnerable person. And the contact with a vulnerable person would reasonably be expected as a normal part of engaging in the activity. As an example, a plumber may need to go into a school one day to fix a broken pipe, but engaging with children is not an expected normal part of being a plumber. Therefore, a working with vulnerable people registration is not required. A working with vulnerable people registration is not an employment, character, or fit and proper person check. It is a background check to determine whether the person presents a risk of harm to a vulnerable person if engaged in a regulated activity. So, all applications for working with vulnerable people registration undergo a risk assessment before a registration is issued. The risk assessment is based on information returned on an expanded criminal history check, which is obtained for all applicants. And by an expanded criminal history check, I mean it includes more information than the typical employment criminal history check, such as spent convictions, non-conviction orders, and charges that didn't result in a finding of guilt. With this in mind, the Working with Vulnerable People Act allows for the following information to be considered when conducting a risk assessment: criminal history, so convictions or findings of guilt for relevant offences; non-conviction information, a charge for a relevant offence where there has not been a finding of guilt, so pending, dismissed charges and acquittals; and any other information relevant to deciding a person's suitability to hold a Working with Vulnerable People registration, such as child protection information, reportable conduct allegations, and professional misconduct. Based on this information, decision is made about whether a person poses an unacceptable risk of harm to vulnerable people. If the person does pose an unacceptable risk, conditions are imposed or the application is refused. The Working with Vulnerable People Act automatically prohibits some people from applying for or holding a Working with Vulnerable People registration that allows them to engage with children. The first category of people that this applies to is people who have recorded what's called a Class A disqualifying offence. Class A disqualifying offences include murder, sexual offences, and serious assaults against vulnerable people. Both convictions of and findings of guilt without conviction count. The person must have been an adult, and by an adult I mean over 18 years old, at the time the offence was committed. And the applicant is prohibited from holding a Working with Vulnerable People registration allowing them to work with children for life unless their offence is quashed or the law changes. And by the law changing, I mean the offence being removed from the Working with Vulnerable People Act's Class A disqualifying offence list. The other group of people who will automatically be refused are people who have had a Working with Children check refused or cancelled in another state or territory, and this is called mutual recognition of negative notices. This only applies if the decision was made by the other jurisdiction in the last 5 years and it has not since been overturned. So, all Working Vulnerable People registrants are subject to continuous monitoring whilst their registration remains active. The Working Vulnerable People team regularly receives information about registrants from the police, Children, Youth and Families, or CYF, the ACT Ombudsman about reportable conduct notifications and substantiations, and we receive all new notifications and all substantiations from the Ombudsman once a month. Any regulatory agencies, members of the public, and employers. When new relevant information is received about a Working Vulnerable People registrant, and what's called an additional risk assessment is triggered, and the person's suitability to continue to hold a Working Vulnerable People registration is reassessed. An additional risk assessment could result in restrictions being imposed on the registration, both interim and final, a temporary suspension of the registration, or a cancellation of the registration. Any information from any source could be considered relevant and could trigger an additional risk assessment. I've talked about types of adverse decisions, but how will employers know an adverse decision has been made against their employee? So the Working Vulnerable People team has an obligation to notify any employer named by an applicant or known to Access Canberra of any adverse decision on the person's application or registration, including an application for registration being refused, a conditional registration being issued, or interim conditions being added to an existing registration, and an existing registration being suspended or cancelled. The Working Vulnerable People team will not be able to provide reasons why the adverse decision was made to the employer unless the person gives their specific consent for that. And I'm sure you can appreciate that's a relatively rare situation. And the Working Vulnerable People team is only able to notify employers we know about of adverse decisions. To assist with this, organisations can require your staff nominate your organisation in their application and update their employer details when they change by contacting WWVP at act.gov.au or ask the WWVP team to add their organisation to the person's WWVP record by once again contacting WWVP at act.gov.au. The Working Vulnerable People scheme includes various legal obligations for everyone involved. I'll start with the obligations for individuals. So everyone has an obligation not to engage in a regulated activity involving vulnerable people without a Working Vulnerable People registration, unless you have an active application, you have not had an adverse Working Vulnerable People decision issued previously, and your named employer agrees to let you engage under the supervision of a registered person, and this is outlined in Section 15 of the Working Vulnerable People Act. Working Vulnerable People applicants are required to be honest in their disclosures when they apply for a registration and notify the team if there is a change in relevant information about them after they file their application, for example, if they're charged with a new offence. Registrants are required to notify the team if they are charged, convicted, or found guilty of a relevant offence. Notify the Working Vulnerable People team if there's a change in relevant information about them, for example, if they're the subject of a workplace investigation or a reportable conduct investigation, and comply with any conditions placed on their Working Vulnerable People registration. For Working Vulnerable People employers, and this includes any organisation engaging a person in volunteer work, they're required to ensure that everyone they are engaging in a regulated activity holds a valid Working Vulnerable People registration. As an employer, you should cite the physical registration card, noting that images and photos of cards can be digitally manipulated, more so than ever in the era of AI. And verify the registration status directly with the Working Vulnerable People team by emailing wwvp at act.gov.au and providing the details appearing on the person's card. Or an employer can agree to engage a person with an active application and no interim bar under the supervision of a registered person. There is no obligation for an employer to agree to this arrangement. Some industries, such as early childcare, employ a no card, no start rule, and it's up to the discretion of the employer. If the person the employer is engaging has a condition on their Working Vulnerable People registration, they need to ensure that they are complying with the requirements of the condition. Now we'll go into risk management for employers, starting with reporting concerns. So there is no obligation for employers to report concerns they may have about a Working Vulnerable People registrant to the team. However, any relevant information you do provide about a registered person or non-compliant person is welcome and will be assessed by the Working Vulnerable People team. The quicker you report any serious concerns you have, for example, allegations of sexual or serious physical assaults committed against a vulnerable person, the quicker the Working Vulnerable People team can act. You can make a report to the Working with Vulnerable People team by sending an email to riskassessments@act.gov.au, and please note the sneaky S at the end of risk assessments. Calling Access Canberra on 132281, or using the online feedback and complaints form to make a report. You can use this form to report your concerns anonymously. The advantage of reporting anonymously is that nobody, including Access Canberra, will know that you made the report. The disadvantage is this means we are unable to follow up with you if we have any questions or require any clarification. Separate from the Working with Vulnerable People scheme, you may have an obligation to report to the ACT Ombudsman as part of the reportable conduct scheme, children, youth and families if you're a mandatory reporter, and or to the police. So as mentioned earlier, the Working with Vulnerable People scheme is part of a broader protective framework to prevent harm to children and other vulnerable people. We are all part of that framework, and a Working with Vulnerable People registration cannot be the only thing you rely upon to manage risk. The Royal Commission identified that most employers were relying on the Working with Children checks as their main strategy to keep children safe, separate from complementary child safe systems and processes. It found that reliance on Working with Children checks as the sole arbiter of an individual's safety and suitability to work with children can create a false sense of security. As Working with Children checks rely on checks of a person's known history of offending or misconduct, they only detect a subset of individuals who are unsuitable to work with children. Individuals with harmful intentions but no prior history, and individuals with a prior history who have evaded detection may still pass the screening process. Whilst it is a legal obligation that any employee you are engaging in a regulated activity must have a Working with Vulnerable People registration, the registration itself should not be your only risk management strategy. So to sum up, it is your responsibility to conduct appropriate employment checks. The aim of the Working with Vulnerable People risk assessment is not to determine whether someone will be a good employee, only that they do not pose an unacceptable risk to vulnerable people based on their known history of offending or misconduct. Something may come back on a person's WWVP background check that is not particularly relevant to their suitability to work with vulnerable people, and therefore would not result in them being refused a registration, but would be relevant to you as an employer, for example, professional practice issues like poor record keeping. While many employers under the Working with Vulnerable People scheme are child safe organisations under the child safe standards, all employers who engage with the Working with Vulnerable People scheme should ensure that they have systems, policies and processes in place to identify, assess and manage risks to children. This includes establishing training, supervision, reporting and human resource mechanisms to effectively implement the child safe standards. That's it from me for now, so I will hand back to Gemma.
Wonderful. Thank you, Isabel. So that was a bit of an overview just at the end there of the role of working with vulnerable people in child safe recruitment. And as Isabel has just stressed, the Working with Vulnerable People card is not employment screening or character checks. So it's only checking that known history of offending or misconduct. So organisations need to do more than just a Working with Vulnerable People check if they are working, or if they've got people who work with children, and they need to ensure that they're assessing a person's suitability. And this is where the child safe standards intersect. So in particular, child safe standard number 5 requires that people working with children and young people are suitable and supported to reflect child safety and wellbeing values in practice. So Child Safe Standard 5 is firstly about ensuring that people are suitable. So that means ensuring that you've got child safety in the life cycle of your recruitment process in an explicit way, and ensuring that you're selecting your staff and volunteers carefully. So we acknowledge that sometimes it can be really hard to get volunteers in some sectors, but if we are delivering services to children, we do need to still make sure that we are considering who we are giving access to children to. You should also be making sure that your recruitment practices are shaped so that you're screening the person's skills, their qualifications, and their, personal suitability to work with children and young people. And Standard 5 is also about supporting your people to be child safe. So this is having appropriate supervision and making sure that your staff and volunteers are confident in knowing what appropriate child safe behaviour looks like. They understand what child safe risks are, and they know how to raise concerns if they have them. Now, this is just one of the 10 child safe standards. And of course, many of the standards are interrelated, and there are other standards which are really critical in ensuring that your people are child safe. So in particular, Child Safe Standard 6 is about concerns and complaints and ensuring that staff, children and families can raise concerns and that you are taking appropriate action when those concerns get raised. Of course, there's a link for Child Safe Standard 6 with reportable conduct as well. And then the other key one for our child safe people is Child Safe Standard 7, which is about training. So equipping your staff and volunteers with the right training so that they understand what child safety means, they understand how they can act and be child safe, and they understand what to do if they see something that is a problem. Now, we know that the child safe standards, when they get written on a page, can sometimes feel a bit vague, and there isn't necessarily a right way to do things. So we've popped up on the screen there some examples of what Child Safe Standard 5 in particular, and that idea of child safe recruitment can look like. So firstly, creating visibility about child safety early on in your recruitment processes is important. So this is things like including a child safe commitment statement on your website and putting child safety into your job descriptions and job advertisements. So that might look like a line in your job ad that says, our organisation is committed to child safety and the successful candidate will need to pass child safety screening. Now, sometimes this feels like it might be tokenistic, but what it does do is it sends a message to prospective employees and volunteers that this is a place that takes safety seriously. The Royal Commission and many, public case studies that have come forth since that time have shown that perpetrators of child sexual abuse often are shopping for the organisation where they think it's going to be easy to get away with it. So those early messages can help send prospective employees the message that you are taking this seriously and that poor behaviour will not be tolerated in your organisation. The next sections that you can do are making sure that child safety is really explicit during your recruitment process. So this is asking questions or including a scenario about child safety during your interviews to assess candidates' understanding of what child safety means, and also just to, again, keep that message front of mind that this is an important piece of your organisation. You should also be looking for red flags in prospective workers' employment history. So this is things like gaps in employment, frequent job changes, or potentially not wanting to give any details about recent jobs. And I guess related to that is reference checking. So it is absolutely critical that you conduct reference or referee checks for everybody coming into your organisation. Even if the person has been, recommended by your current CEO, you should still be conducting a reference check. Ideally, this should always include recent employers, even if it's as simple as asking for their HR contact, just not necessarily to scope out whether they, what their capabilities are and their strengths and weaknesses, but just to verify their employment and make sure that there was no conduct issues that has led to their, reason for shopping for a new job. I would always recommend that you, again, are explicit in asking questions about suitability to work with children during those reference checks. And this doesn't need to be complicated. It can be as simple as saying, do you believe this person is suitable to work with children? Or is there any concerns that you have about this person working alongside children and young people? It's often very obvious very quickly if there are concerns there when you are speaking to somebody. Now, working with children checks or working with vulnerable people checks are, of course, one form of pre-employment screening. And if you are required by law to have those, then you must ensure that that your prospective employees have them. But there is further pre-employment screening that you can consider. So this is things like national police checks or international police checks if the person is coming from overseas. It's things like identity verification, checking qualifications, and of course there are things like psychometric testing, which can give you an idea of a person's work style and also any red flags that they may have. Now, we acknowledge that these things can take quite a lot of resources and capability, and depending on the size of your organisation, you might not have the ability to do them all. But under the standards, this is where we encourage organisations to think about their size and their risk, and to put in place the screenings that are going to give them the best picture of whether a person is suitable to work within their organisation with children and young people. And then finally, the last actions are really about what you do once that a person has been appointed and they're arriving to start work with you. So providing an induction that includes information on child safety. Safety should be something that they are hearing about on day one of the job. And you want to make sure that they're really clear about behaviours and that you're providing them with information about reporting concerns. And again, it's about culture. So making sure that in those early days, they are getting an understanding that this is an important part of their job and that, if they do have concerns, they will be supported to raise those. All right. So those are just some ideas. They are, of course, not the only ideas. And if you need more help and some practical examples, our team has a self-assessment guide up on our website, and we recommend that you go and have a look at that. And you are, of course, also welcome to contact us. We also have a guideline about child safe recruitment. So this is more detailed, and it's got many of these steps up on the screen in much more detail. So we will share the link to that in a follow-up email. But in the meantime, suggest you head to the website to take a look. Now, that brings us to the end of our formal presentation element of today, and we've got some time for Q&A. So I can see the chat is going crazy, and there's lots of people asking questions in there, and Kathy is doing a great job of responding to many of those. But we did also have a couple of questions that had been submitted in advance, which we thought we would kick off with. So the first couple of questions I will be handing back to Isabel. So the first question was, when an employee's registration is suspended or revoked, do they have to surrender their card?
So thanks, Gemma. At the moment, no, they do not have to surrender their card. We certainly ask them to surrender their card, but it's not a legislative obligation for them to do so, which is once again why it's so important for employers to make sure that their employee details are up to date so that they will be notified directly if there is a change to registration status, and also when they take on a new employee to verify their registration status.
Excellent. Second question was, is the working with vulnerable people check the same as a criminal history check?
So once again, no, I touched on it in the presentation, but we get significantly more information back on a working with vulnerable people criminal history check than you would get back on a typical employment screening check. So typical employment checks you only receive information about what's called unspent convictions, which, I mean, I could go into the the full definition of it, but essentially you have to have been convicted by a court of law for the offence. It has to have happened in the last 10 years, or you have to have been sentenced to more than 6 months imprisonment for it to be an unspent conviction. Working with vulnerable people, criminal history checks include every single time a person has ever been charged with an offence, regardless of the outcome, including juvenile offences. And we're able to take all of that into consideration under the Working with Vulnerable People Act. But at the same time, stuff may come back on the check that wouldn't be particularly relevant to engaging with vulnerable people, but would be relevant to employers, which is why it's also important to do your own background screening. So, for example, if someone has previously been found guilty of stealing from their employer, that may not necessarily be particularly relevant to us in the working with vulnerable people space, but could be very, very relevant to you as an employer, particularly if you're wanting to employ someone to be responsible for money and transactions.
Wonderful. Thank you, Isabel. Third question there is for myself, and it says, what records do organisations need to maintain for child safe standards? So the child safe standards at this stage do not have a formal compliance mechanism. So there isn't an audit program or fines or anything like that that is in place yet. And I do say yet because that arrangement is going to be reviewed after the first 5 years of the scheme. But that being said, it is important that you are putting in place what you need to do for the standards, and part of the standards themselves are about continuous improvement and having policies and procedures. So absolutely, whilst there isn't a minimum number of records, it is highly recommended that you are doing things like documenting your child safe code of conduct, putting in place a reporting procedure, having a complaints and allegations procedure. Of course, if you are in reportable conduct, that is required under that scheme, but even if you're not, this is something you should be doing. You should be keeping records around things like working with vulnerable people, as well as your training, so that you know that your staff are completing training. And absolutely, where you have had issues or concerns raised, you should be documenting how you have handled those and any changes that need to happen as a result of what gets uncovered for an investigation process. I can see the chat is going crazy, so we're going to now move to trying to address some of those questions that haven't yet been answered. So I can see one here that says, are there any suggested or endorsed child safety training guides or courses for new employees to complete, rather than each organisation creating our own or starting from scratch? So the simple answer is yes. There is a number of training options out there. In terms of the child safe standards themselves, there is online training that is available from the National Office for Child Safety that looks at the child safe standards or the national principles for child safe organisation. There is a summary one that I think is about an hour long that covers all 10 of the national principles, which are the same as the standards. And then there are 10 separate modules for each of the standards. So the person who is responsible for implementing this in your organisation might like to go and do all 10. Our office also has some training that is currently available to ACT government employees. We are hoping to make that available to anyone through our website. We're just finding an appropriate platform for that at the moment. And, you know, whilst the ACT Child Safe Scheme is, you know, just for the ACT, many other jurisdictions have also legislated child safe standards. So the New South Wales Office of the Children's Guardian has an online module and a number of videos that can be really helpful, including videos by sector. So they have some great resources for early childhood and sport. And of course, depending on your sector, there may be further child safe modules that are of interest. So for example, early childhood has a new mandatory scheme. All right, let's go to more questions. There is one here that says, at what stage of a reportable conduct investigation should we alert Access Canberra? So, Isabel.
So as I mentioned, the sooner the better if it's a particularly serious allegation. So if it's an allegation of sexual abuse in particular, or a very serious physical assault against a child, the sooner we know, the sooner we can start the mechanisms to put mitigation in place, like a suspension or an interim condition. However, you don't need to report to us in the sense because we will get the information from the Ombudsman. But as I mentioned, we only get notifications from the Ombudsman once a month. So if something happens on the 1st of September, we won't receive a notification about it until beginning of October. And particularly in those very high risk cases, the sooner we know, the better.
Wonderful, thank you. So another one for you, Isabel. It says, if a survivor of historic childhood sexual abuse would like to provide information to working with vulnerable people about their perpetrator being a current card holder, would this information lead to the card being suspended?
It would depend on a lot of factors. So certainly it would trigger an additional risk assessment and we would have to obtain further information. But an allegation in its own right without any other evidence is typically not going to be enough to prompt any kind of adverse decision being imposed on a registration. But often those allegations come with other things, and there are certainly other avenues for inquiry that we would dig into. And certainly for an allegation of sexual abuse involving a vulnerable person or a child, we would use every single mechanism available to us to gather information and potentially impose some kind of adverse decision.
Excellent, thank you. The second half of the question also related to, would the cardholder be entitled to the information provided? I know you said during your presentation that there was a way to anonymously report. So presumably if an individual wanted to share details about potential childhood sexual abuse, historical or otherwise, but they were concerned about their identity being revealed, they could use the anonymous form.
Mm-hmm. Yep, that's right. We would have to give at least some details about what we were investigating because we need to give the registrant procedural fairness before imposing any kind of decision. So it's not really affording someone procedural fairness to say we're suspending the registration and we can't give you any details about why. But certainly, if the person were to report through that online form, the feedback and complaints form, then if they chose not to reveal their identity, we would have no way of ever knowing who it was, and so the registrant would also not know who it was as long as there's no identifying information in the complaint itself.
Excellent, thank you. I would probably also just add to that particular query about childhood sexual abuse. We haven't covered today mechanisms around reporting to police for those who are survivors or victims of any form of child abuse. But absolutely, if you or somebody that you know has experienced childhood abuse, please know that there are reporting options available to you, including the police. If your historic childhood abuse was in relation to an institution, the National Redress Scheme also exists. We haven't touched on that at all today, but you can look that up online if abuse from your past or somebody you know's past relates to historical abuse. The redress scheme may be able to assist and support you. Okay, I'm not sure if there are any other questions that haven't yet been covered. Kathy has done a great job in answering many of the questions that are in there. I'll just give a minute if anybody wants to post anything else. In terms of the questions, we will create a little bit of a Q&A document from today's session, summarising some of the questions that have been asked, and we will make sure that this is shared to participants. And Rosetta, yes, absolutely, you are able to get contact details for us. Let's move to the next page on the slide. So some contact details are there for us, and you can send us an email if you would like a copy of the slides. The slides won't be published publicly, but we are happy to send them out to you just for your own use. Final couple of questions have come through. So since we still have a few minutes, we have a question that says, how do we check if our training falls under regulated activity? Isabel?
Yeah, if it's not clear, I would suggest contacting working with the WWVP at act.gov.au email address and provide. Sometimes it's difficult to unpack whether or not something is a regulated activity or not in this kind of forum. So it's best if you just send through an email providing all of the details about exactly what the activity is, and someone will be able to give you an answer in writing.
Wonderful, thank you. Further question says, I've seen the advice on 7 days per 12 months for volunteers. What about subcontractors or employees?
So the 7 days exemption applies to both volunteers and employees. So what's being referred to there is that you can engage in a regulated activity without a registration for up to 7 days in any 12-month period. Yeah, that applies to both volunteers and employees.
Wonderful, thank you. And I know that in advance of today's webinar, we did have some questions asking about what that 12 months mean. So can you just clarify, Isabel, whether that means sort of a calendar year or a financial year or something else?
I believe the wording is in any 12-month period. So it's from the date of the first engagement to the date of the last engagement. So 12 months starting from the first date that someone engages in a regulated activity without a registration. But Kathy can correct me if I'm wrong, if I'm misremembering the legislation.
Excellent, that's a good explanation. And I think I know that one has been raised before, particularly in relation to schools. So if you are a school or a preschool, or maybe you're a sports club that runs on sort of school terms, you know, if you've got a volunteer or an employee who starts with you in December and does a few days, and then they're, you know, back in February for the new school year, it doesn't reset in January and it rolls on through. So. All right, well, it doesn't look like we've got any further questions. So I just want to thank everybody online for your time today. If you do have questions that you haven't been able to post today or something comes up, please contact our teams. We are always happy to help, whether that's answering questions or in the case of the Child Safe Standards team, we are also offering you know, we can come and talk to your staff and your organisations about the standards if that's something you're interested in. We do also have, for the Child Safe Standards, 2 further webinars coming up shortly, which may be of interest. So the Introduction to the Child Safe Standards webinar will be running again on March 26th. This is an introductory webinar which covers off what the Child Safe Standards are and what organisations need to know. We also have the next webinar in this current series around Child Safe Standards and Regulation, which will be on the Child Safe Standards and Reportable Conduct Scheme. That is scheduled for late April, and we will be sharing more details and posting registration links up on our website for that shortly. So do keep an eye out if you are working for an organisation or a sector that is covered by reportable conduct, or maybe you're not sure if you are covered. So more details to come on that one. Otherwise, thank you all very much for your time today. As I said, if you would like a copy of the slides, please contact ACT Child Safe team, and we will send those out to you. Thank you to Isabel and Kathy for your time today, and please keep in touch, everybody. Thank you very much.